hearing in the appeal, the Queen against Adams.
Good morning, Mr. Doran.
Good morning, my lord. My lords, my lady, I appear on behalf of the appellant with my learned friend, Mr. Donald Sayers.
Mr. McGlean and Mr. McLaughlin appear for this one. We've got a quirky tradition here that you introduce your opponents as well as yourself.
Yes, indeed. By way of introduction, this is an appeal against two convictions that date back to the 1970s. The convictions related to two separate offences of attempting to escape from detention. The appellant had been detained on the authority of an order for executive detention under the emergency provisions legislation that was in place at the time. His appeal against the convictions was dismissed by the Court of Appeal in February of last year. Having dismissed the appeal, the court acknowledged that a point of law of general public importance was involved.
Yes.
And the point is set out, it's a fairly discrete point, it's set out at paragraph 4 of the appellant's case. That's at page MS 76.
So discreet that we're confident that we can accommodate the appeal comfortably within the time allocated.
Yes, yes, absolutely.
Yes.
Now,
That's not to say that it's other than a very important point, of course.
yes. So the question, my lord, whether the making of an interim custody order under Article 4
Yes.
of the Detention of Terrorists Order required the personal consideration by the Secretary of State, or whether the Cartona principle operated to permit such an order by a minister. Now, my lord, it's a discrete point of public law. This is, of course, a criminal appeal, and the overriding question in the appeal is whether the court thinks the conviction is unsafe. And if the point of public law is resolved in the appellant's favour, we respectfully ask the court to rule that the convictions are unsafe and should be overturned. My lords, my lady, with the permission of the court, I wish to advance the submissions on behalf of the appellant in 6 stages. Some of these will be very short indeed. I want to begin, firstly, by looking briefly at the chronology that led to the convictions and the appeal. Secondly, again briefly, I will look at the short life of the legislative provision that is at the heart of the appeal, as I think this is an important matter in order to put the point properly in context. Thirdly, I wish to make some introductory remarks about the Cartona principle and key question before the court. Fourthly, I will then focus on the wording and framework of the relevant legislation. Fifthly, I will address the specific reasons put forward by the respondent that they say point away from the interpretation we are advocating. And sixthly, then, I want to say something remaining on Cartona about the serious nature of the power that is being considered by the court. Before I conclude, I will also refer very briefly to some other points that have arisen in the case,
Yes, of course.
but shouldn't trouble the court today. So first, very briefly, the chronology, which may assist with the legal submissions in the case.
Well, you may take it that we've read the cases and on the printed cases for both parties, and
Yes.
we're broadly familiar with the chronology, so you can take that fairly
Yes, indeed.
briskly.
Indeed. My lord, the key event, obviously, was the purported making of an interim custody order
Yes.
under Article 4.1 of the Detention of Terrorists Order 1972. Now, the document appears at MS 174. It's worth perhaps just looking at the text of the document at the outset. It reads, Interim Custody Order. The Secretary of State, in pursuance of Article 4.1 of the Detention of Terrorists Northern Ireland Order 1972, hereby orders the detention of Gerard Adams, 18 Harrogate Street, Belfast, being a person suspected of having been concerned in the commission or attempted commission of an act of terrorism, or in the direction, organisation or training of persons for the purpose of terrorism. The person aforesaid shall not be detained under this order for more than 28 days unless his case is referred to a commissioner for determination.
Yes.
And it's dated the 21st of July and signed by the Minister of State, Northern Ireland Office at the relevant time. And notably, the order is addressed not only to Mr. Adams himself, but also to the Governor or other person in charge of HM Prison, the Maze. So this really is the key foundational document that authorises the detention of the appellant at the relevant time. Now, we know from the documentation that has been obtained for the purposes of the appeal that the appellant's case was not, in fact, considered by the Secretary of State. And how we know that is that there was a meeting in relation to the case held by the Prime Minister at the time, Mr. Wilson, on the 17th of July 1974. Now, there is a note for the record of that meeting, and it appears at MS 204. And I'm not going to take the court through the entirety of that document, but the note of the meeting records as follows. The Attorney General explained that following a recent attempt to escape by 4 prisoners from the Maze prison, an examination of the papers concerning these prisoners revealed that applications for interim custody orders concerning 3 of them had not been examined personally by the Secretary of State for Northern Ireland during the Conservative administration. I think the change of administration had taken place in March 1974. So that confirms that the Secretary of State himself didn't consider personally the appellant's case. The legislation...
Well, I think that's agreed, isn't it?
Yes, it is, indeed, my Lord. The legislation also required then that the case of a person subject to an interim custody order should be brought before a commissioner, and that had to be done under the legislation within 28 days. That was done on time in the appellant's case. I needn't take the court to the notice of reference, but the notice of reference to the commissioners on the 10th of August 1973 is in the papers at MS 176. Now, the first attempted escape from custody was on the 24th of December 1973. At that point in time, the appellant's case had not actually been considered by a commissioner. So the document authorising detention at that point in time was the interim custody order to which I just referred the court. On the 16th of May 1974, a detention order was made by a commissioner. And that document, again, I don't need to look at it in detail. It appears for the record at MS 250. So on the 16th of May, the detention order was made by the commissioner, and the detention order was in place at the time of the second escape on the 26th of July 1974.
Yes.
Now, critically, However, the detention order was made on foot of the original interim custody order signed by the Minister of State. And in the Court of Appeal, it was argued on behalf of the respondent that the later detention order might cure any defect in the original interim custody order.
Yes.
In respect of the second attempt at escape. But the Court of Appeal disagreed, and the respondent doesn't pursue that point on appeal. So really, again, everything goes back to the original interim custody order signed by Mr. Howell. The convictions eventually followed then on the 20th of March 1975 and the 18th of April 1975. And the appellant received custodial sentences in respect of each. 18 months for the first offence and 3 years for the second offence to run consecutively.
Yes.
Now, as the court will be aware, the appeal in the case was prompted by the obtaining of materials under the 30-year rule, and those papers indicate that there was an awareness of this issue at the time on the part of the prosecuting authorities. There was also a considerable degree of debate within the Northern Ireland Office and the Home Office as to which interpretation of the legislation was correct. Was it the case that the matter had to have personal consideration by the Secretary of State, or could the Minister of State himself take the decision to make the order? And significantly, the materials that were obtained included an opinion by the then Senior Crown Counsel, Mr. Hutton QC, as he then was, later obviously Lord Chief Justice and Lord of Appeal in Ordinary. And as the court will be aware, his opinion at the time was that a court would be likely to accept the argument that the case required personal consideration by the Secretary of State.
Right.
So, somewhat ironically, all these years later, this court is presented with the question on appeal as to which of these two interpretations of the legislation.
But the circumstance that the senior counsel to the Attorney General had expressed one view doesn't answer the question whether the key to Pepper and Hart is unlocked, does it?
No, it doesn't, my lord. And I have to accept that I cannot place reliance upon the opinion of Senior Crown Counsel in that way. I think what I can do, respectfully, is to suggest to the court that, in fact, he got the matter absolutely right when he considered it. And in fact, there are some of the points that he makes in his opinion are expressed in a much more eloquent fashion than I could possibly express them. And I
don't be modest, Mr. Doran. I'm sure you can rise to the occasion.
But my lord, what I will say is that there may be occasions on which I will wish to say to the court, look, this point was actually answered by Mr. Hutton in his original opinion.
Yes, God.
And here we have it. And there is also something else that I will wish to say about the opinion, and that relates to Mr. Hutton's reference back to the wartime detention cases.
Yes.
We say that they are, in fact, quite analogous to the situation that was being dealt with by the 1972 order.
Right.
So, Lord, that's the second stage then of my submission. Moves on to the short life of the 1972 order. And the matter's dealt with at paragraph 7 to 16 of the case, page reference MS 77. It's also dealt with very helpfully in the Ireland and UK judgment, which appears in the authorities at tab 9, and that's MS 790 at 8816 to 824. I'm not going to, again, my lords, go into this history in detail, Basically, this 1972 order was a short-term measure. It was introduced at Westminster in November 1972 to provide a new system for, a new framework, I should say, for the system of extrajudicial detention or internment, as it was commonly referred to. The order replaced the previous scheme that provided for extrajudicial detention under the old Civil Authority Special Powers Act 1972 and the regulations made under that legislation. The Northern Ireland Parliament had been suspended in March 1972 by virtue of the Northern Ireland Temporary Provisions Act 1972, which appears in the Authorities Bundle at tab 14, MS 984. Importantly, in September 1972, the government had appointed the commission chaired by Lord Diplock to consider legal procedures to deal with terrorist activities in Northern Ireland. The 1972 order was essentially a stopgap between the setting up of the Diplock Commission and the introduction of comprehensive legislation dealing with the response to terrorism that would follow with the Northern Ireland Emergency Provisions Act 1973. The 1972 order, I've referred to its short life. It was repealed on the 8th of August 1973 by the Northern Ireland Emergency Provisions Act 1973, to which I've just referred. The 1973 Act provided for an almost identical scheme for extrajudicial detention within Schedule 1, paragraph 11. And significantly, Section 31(5) of the 1973 Act provided, in summary, that anything done under the preceding legislation shall have effect as if done under the 1973 Act. So, in basic terms, the interim custody order made in July 1973 under the 1972 order continued in effect from the 8th of August 1973 as though it had been made under the 1973 Act. But as I've said, and I keep coming back to the point, for the purposes of the appeal, all the focus is on the interim custody order made under Article 4.1 of the 1972 order. And before moving on to the central part of our case, it's perhaps worth looking at the precise wording of Article 4.1 and Article 4.2 of the 1972 order. And the provision appears at paragraph 6 of our case, that's MS 76. And the legislation itself is at tab 1 of the authorities at MS 615. I'm just going to read the text before moving on to the next stage of my submission. Article 4.1, where it appears to the Secretary of State that a person is suspected of having been concerned in the commission or attempted commission of any act of terrorism or in the direction, organisation or training of persons for the purpose of terrorism, the Secretary of State may make an order, hereafter in this order referred to as an interim
Sorry,
order.
what's the MS number again, please?
It's MS 615
615.
for the legislation
No, 615 is fine.
itself, and the provision appears at 616.
Yeah, thank you.
And then Article 4.2, an interim custody order of the Secretary of State shall be signed by a Secretary of State, Minister of State, or Under Secretary of State. As we know, in this case, the order was signed by the Minister of State.
Yes.
It wasn't considered by the Secretary of State. The Court of Appeal decided that the order was nonetheless saved by the operation of the Carltona Doctrine.
Yeah.
And effectively, the Court of Appeal said that the order of the Secretary of State could be made by the Minister of State, who would essentially be acting in the capacity of Secretary of State for the purposes of Article 4.1.
Well, there is a contrast to be drawn, is there not, between the use of the definite article in 4.1 and the use of the indefinite article in 4.2, where it appears to the Secretary of State that a person is suspected. An interim custody order shall be signed by a Secretary of State, Minister of State, or Under Secretary of State.
Yes. My Lord, we go on to say something about that in our case. Now, we accept that the term Secretary of State can mean any of the Secretary of States as such.
Well, it depends which provision you're looking at, doesn't it?
Well, my Lord, if one first of all takes Article 4.1,
Yes.
standing alone, where it appears to the Secretary of State that a person is suspected of having been concerned in the commission of terrorism, the obvious expectation, we say, was that that role would be fulfilled by the Secretary of State for Northern Ireland.
Person.
Sorry.
Or an appropriate person.
Well, we say the only appropriate person would be a Secretary of State. And now we accept, my Lord, and I'll perhaps deal with this in a little bit more detail later, we accept that the Secretary of State could in fact be another Secretary of State.
Right.
But we say that the order had to be made by an individual at the level of Secretary of State.
And you say that would be the case if 4.1 stood alone? If Article 4.1 stood alone?
We could not make that argument, my Lord.
So it really does depend upon the comparison between 4.1 and 4.2?
It depends on, yes, indeed. It depends on the wording and framework of Article 4.1 and Article 4.2 read in conjunction
Right together,
with each other.
yeah.
So I would have to accept that if it were an open-ended provision without Article 4.2, we could not make the case that we seek to make before.
Despite the nature of the power?
My Lord, it might be possible for an argument to be advanced that having regard to the nature of the power, it can be implied that Parliament intended only to confer such a power upon an individual at the level of the Secretary of State. It is a legitimate argument, we say, that could be made, having regard to the authorities on the implied displacement of Carltona. But I have to accept that the argument simply wouldn't have the same force if Article 4.1 stood in isolation from Article 4.2.
Yes.
We say really that when one looks at the two provisions in tandem with each other and seeks out what the intention of Parliament was, we say that there was an intention here really quite clearly to delineate between the person who can sign the order and the person
who considers the question.
My Lord, just one point I will make in passing, following on from your Lordship's reference to a Secretary of State in Article 4.2. It should be noted that when the provision was reproduced almost entirely identically in Schedule 1 to the 1973 Act at paragraph 11, and that is at MS 645. Interestingly, the only change in the wording was that
Yeah.
the
A Secretary of State became the Secretary of
yes,
State.
yes. My Lord, I can say that we have analysed this matter at length, and we don't think that anything turns on it, because in either event, the words Secretary of State are a reference to an office that can be performed by any one, or functions that can be performed by any one of Her Majesty's
What's the
secretaries.
provision at 645, please? Which particular provision?
Yes, it's if one looks at paragraph 11,
Yes.
11.1 reproduces in its entirety Article 4.1 of the 72
Yes.
Order.
But
11.2,
11.2 substitutes the definite article for the indefinite article.
yes,
Yes.
yes, my Lord.
But you don't think there's any significance to be attached to that?
We don't, my Lord.
Right.
But, my Lord, I have mentioned the Court of Appeal's approach to the matter. The Court of Appeal said, well, this is saved by, the order is saved by Cartona. Cartona applies. I'm not going to address the court on the history of the Cartona principle. The core statement of principle is rehearsed in paragraph 14 of the Court of Appeal's judgment, and that's at MS 3940. The Court of Appeal then went on to summarise the principle and its reach at paragraph 42 of the judgment, and that's at MS 50. And the court set out what it said were the key principles within the operation of the Cartona principle. The key point for the purpose of this appeal, and it's a point that I touched upon in my response to His Lordship's question earlier, and that is that the application of Cartona can be displaced expressly or by necessary implication.
Yes.
In determining whether Cartona is displaced or should not apply, the court is asked to have regard to the seriousness of the subject matter, the context of the provision at play, and a crucial question to be asked is, given the seriousness of the subject matter, can it be implied that this is a scenario in which Parliament didn't intend Cartona to apply? I don't need to go into the authority in any detail, but Cartona was distinguished relatively recently in the decision of this court in Burgas.
Yes.
And the Burgas appears at Authorities tab 4. It's MS 663. And this was a case in which, as I've said, Cartona was distinguished. A senior prison officer had authorised continued segregation of a prisoner for more than 72 hours. The power to authorise segregation was conferred on the Secretary of State. The court held that the senior prison officer was not a departmental official and was not therefore in a position to make the decision on behalf of the minister, for which the minister himself was constitutionally responsible. But the reason I refer to the case is that the court, we think, framed the key question in a very helpful way at paragraph 52, and that's at MS 690. And the court said it is also possible that the performance of and this is at paragraph 52, it is also possible that the performance of statutory ministerial functions by officials or by particular officials may be inconsistent with the intention of Parliament as evinced by the relevant provisions. In such circumstances, the operation of the Carl-Tona principle will be impliedly excluded or limited. And in this case, we say that the exercise of the power was, in fact, inconsistent with the intention of Parliament as evinced by the relevant provisions. We deal with this in detail at paragraphs 53 to 83 of our written case, and that's MS 91 to 100. The court will see that there are two main strands to the argument, and I've touched upon these strands in my earlier response. First, we say that the wording and framework of Article 1 and 2 considered together are suggestive of a legislative intention to oust Carl-Tona. And secondly then, we say that the subject matter of the decision is at the extreme end of the spectrum of seriousness, involving, as it did, detention by the executive without charge and without trial. And in keeping with these submissions, as I indicated earlier, we say that Mr. Hutton's opinion on balance remains every bit as potent today as it was in 1973.
Yeah.
So I want then, my Lord, to move on to stage 4 of the submission, and that concerns the wording and framework of the legislation. And the court will apologise for a little bit of repetition here. I just want to reinforce 3 key points about Article 4.1 and Article 4.2. Quite obvious observations, but important observations nonetheless. Article 4.1, 3 observations. Article 4.1 refers only to the Secretary of State as the person who has to be satisfied of the relevant conditions and who may make the order. I've accepted, my Lord, that looking at this provision in isolation, it's difficult to make the order.
Cartona would clearly apply, wouldn't it?
Yes.
If you look at Article 4.1 without contrast with Article 4.2.
My Lord, without the contrast,
Yes.
as I've said, the case is more difficult to make.
Right.
Without the contrast, we can rely solely on the seriousness of subject matter.
Yes, quite.
But we accept that there's nothing, if I can put it this way, we accept that there's nothing unique about the statutory formulation in Article 4.1 standing alone.
Mm-hmm. Right.
But the second point, as we know, is that Article 4.2 deals discreetly with the power to sign an interim custody order as distinct from the power to make an interim custody order. As the court has seen, an order may be signed by a Secretary of State, Minister of State, or Under Secretary of State. There's a clear intention, we say, to differentiate between these two functions. On the one hand, the making, and on the other hand, the signing. Lords, my lady, the third point or observation on the wording and framework of Articles 4.1 and 2 is that Article 4.2 refers specifically to an interim custody order of the Secretary of State. An interim custody order of the Secretary of State. And we say that the use of the possessive of was intended to reinforce this distinction between the maker of the order on the one hand and the persons who could sign the order on the other. And just taking that one step further, we say that this is a potentially significant point, because if Carl Tona applies, the question arises as to why those words of the Secretary of State were necessary at all. If one looks at Article 2.2 of the order, and Article 2.2 appears at MS 616. It's the interpretation provision within the 1972 order. And at the top of MS 616, one sees that interim custody order has the meaning assigned by Article 4.1.
Not so sure that that's all that helpful, is it really?
Well, my Lord, what we say is that if Carl Tona applies, then any order made by or under Article 4.1 is in fact an order of the Secretary of State. Mm-hmm. So those words, if Carl Tona applies, we say it wasn't necessary to include those words within the provision. We say the words were actually inserted with a clear intention to reinforce this distinction between the person who can make and the persons who can sign.
You focused on of, the word of,
yes,
the Secretary of State. But
yes.
It's interesting, isn't it, that it's of the Secretary of State and it can be signed by a Secretary of State.
Yes. My lady, we would have to, or I accept that the words Secretary of State have the meaning, and it's a provision in the Interpretation Act to which I'll take the court, have the meaning any individual who holds the office of Secretary of State.
Yeah.
So we accept that technically it would be possible for an order to be made by one Secretary of State and signed by another. Highly unlikely for that to happen in practice.
Well, in fact, it could be made by a Secretary of State and signed by a Minister of State, couldn't it?
Oh, yes, my Lord, but that's clearly what the order envisaged, we say.
Yeah.
And indeed that would be a normal course of events in circumstances, for example, where the Secretary of State himself was out of the country. And
Right.
I'll come on and look at that in a little bit more detail in a moment.
It might support a differentiation between what's happening in one and what's happening in two. It's referring back to one.
Yes.
And this is the Secretary of State. Whereas this is another category of people in which a Secretary of State features.
Potentially, my lady, our difficulty with that argument is that looking at Article 4.1 again in isolation, I think that due to the provision within the Interpretation Act, it would be difficult for us to argue that the making function couldn't be performed by
By a
Secretary of State.
from
Yes.
Or a Secretary of State other than the Secretary
Ireland.
of State for Northern
Yes.
Ireland.
I'm just
Certainly not a Minister of State.
wondering whether it suggests, and the correction in the subsequent schedule suggests that there wasn't a complete understanding of that function of the office of Secretary of State.
Perhaps.
We're
my lady,
speculating, but
yes,
it's an interesting use of two articles.
yes, it's a possible explanation, although, again, it seems to me that normal expectation in practice would be that if the Secretary of State makes an order, he signs it as well, and that the same person, in the circumstances of a Secretary of State making an order.
Yeah.
Although the Secretary of these needed to be signed in Northern Ireland, didn't they?
Yes.
And so it's not impossible to envisage that the Secretary of State might be in London or elsewhere, makes the order but isn't physically present in Northern Ireland to sign it where it needs to be executed.
Indeed, my Lord. And that was a point made by Mr. Hutton in his opinion, and there were also arrangements made under the subsequent Secretary of State, Mr. Rees, who was Secretary of State under the Labour government. It was Mr. Whitelaw who was Secretary of State at the time of the signing of this order. But we will see, and I'll come to this in a moment, that specific arrangements were made by Mr. Rees to ensure that if he were out of Northern Ireland, there would be lines of contact between him and the duty minister, as he described the other office holder.
I suppose your argument really is the framework of 4.1 and 4.2 implies, indeed explicitly provides, that the Secretary of State makes the decision and a Minister of State, for reasons of expediency, can sign the order.
My Lord, we say it's as close as can be to express displacement of Carltona.
Right. All right, where are we now then?
Yes, I'm still on stage 4 of my submission, and I wanted to pick up on one thing at this point that the respondent says at paragraph 8 of its case, and that's at MS 121. And the respondent says that Article 4.2 places a restriction on the range and status of persons who may exercise the ICO power on behalf of the Secretary of State, namely ministers. And they say, to quote, by precluding the possibility that officials might make ICO decisions, Article 4.2 contains a partial displacement of the Carltona principle, but expressly preserves its application to junior ministers. Now, in our submission, that is an extremely strained interpretation of the relevant provisions. The respondent appears to be contending that Parliament wanted to ensure that ICOs could only be made by the office holders specified in Article 4.2. And if that were the objective, if that were indeed the objective, Article 4.1 and Article 4.2 was an incredibly clumsy way of achieving it.
Well, another way of putting that is that the juxtaposition of 4.1 and 4.2 makes it improbable that the intention of the legislature was that the power to make the order was available to all of the people specified in Article 4.2, when in the very next provision the power to sign the order was extended to all of them. I suppose you would say was, at the very least, highly incongruous that that was put in the legislation.
What we say is this: if Parliament wanted to provide for the making of the order by all of those specified office holders, then it would have been incredibly easy for Parliament to say where it appears to the Secretary of State, Minister of State, or Under Secretary of State that a person is suspected of involvement in terrorism.
Right.
He or she may make an order.
Yeah. Of course, there is the consideration that if 4.2 wasn't present in the legislation at all, then 4.1 would have extended the power to make the order to all of those.
Potentially subject to our context argument.
So 4.2 is pivotal, really, to your case, isn't it?
Yes, it is indeed. My Lord, we do agree that Article 4.2 involved a displacement of Carltona, and it did so in this sense. Given the seriousness of the provision, we say it's a reasonable interpretation of that provision, that is Article 4.2, that an order would be valid only if signed by one of the specified office holders. There was simply no room, we say, for subordinate officials to play a formal role in this decision-making process.
As I understand your submission, you say that 4.1, if Carltona applies to it, would permit the decision to make the order to be made by a much broader class of persons than those in 4.2.
Potentially, yes, my
And,
lord.
and your submission, as I understand it, is it would be rather strange that the making of the order could be by any official, but the signing of the order has to be by one of these three specified officials.
Yes, it would be highly unusual, although, my lord, I would accept that were a decision to make an order made by a subordinate official beyond the ministers specified in the legislation, one might then have a separate challenge based on Wednesbury unreasonableness. That, given the seriousness of the decision, how could it possibly be conferred upon someone of a lower rank? So, I mean, if the Secretary of State had allowed the decision to be made by officials, then probably there would have been a fairly significant basis on which to challenge such a decision through the Wednesbury route. But yes, my lord,
But my lord's point is that 4.1, if it stood alone without 4.2, by virtue of the application of the Kaltona principle, could have meant that a senior civil servant, for instance, could have made the order. But once you introduce 4.2 and you restrict the class of persons who can sign the order, then it would be anomalous if Article 4.1 could be given the extended application that is contended for by the respondent.
And we agree with that.
It would put the signer of the order into an invidious position because it has not appeared to him that that's the situation. It has appeared to the civil servant.
Yes.
That's the situation.
Yes, indeed.
Right, where are we now, Mr. Jordan?
My lady, my lords, we say obviously that not only the textual analysis assists us, but the nature of the power and the context and the seriousness of the matter, and I'll come on to that in due course. What I want to do now in stage 5 of the submission is to address specifically the 4 reasons that the respondent says point away from the interpretation of Article 4.2 that is being advanced on behalf of the appellant. And in paragraph 40 of the respondent's case at MS 121, the respondent describes our interpretation of the provisions as a literal interpretation. I must say, my lord, I don't quibble too much with that description, because we say that the provisions do quite literally point to a bifurcation of function, as I have submitted. But looking closely at the 4 reasons submitted, advanced on behalf of the respondent, we say that they are each flawed. And I'd like to look at these in turn with the court's permission. First of all, and this is all at paragraph 40 of the respondent's case. First, the respondent says, if the intention of Parliament had been simply to enable ICOs to be signed by a third party on the direction of the Secretary of State, it is difficult to conceive of why this would have to be done by a minister. The respondent says that execution of the order could properly be effected by an official, provided that he or she acted on the Secretary of State's direction. Related to this, then, is the submission that it would be unusual to refer expressly to the junior ministers, that is, the Minister of State and the Parliamentary Under-Secretary, and yet restrict them to what is described as an essentially administrative role rather than a decision-making role. Now, we say that the answer to this is that the signing of the document by someone other than a minister would simply have been unacceptable. In due course, I will be looking at the qualitative nature of the decision in question. As I've said, it was a power of executive detention without charge or trial. And, my lord, At this point, I'm going to revert to the course that I suggested I may do earlier in my submission, because Mr. Hutton answered this particular point very comprehensively in his opinion in 1973. And can I refer the court to paragraph 12 of the opinion at MS 188. And it's towards the bottom of the page. He says, in reply to the contention that it could not have been intended that a Minister of State or Under Secretary of State should merely act as a clerk in signing an order which the Secretary of State had decided to make, I consider that it could be argued that there would be occasions when the Secretary of State would not be in Northern Ireland, and when it would be necessary to have an interim custody order signed quickly by the Minister of State or Under Secretary of State who was present in Northern Ireland, acting on the instructions of the Secretary of State in respect of a case in which the Secretary of State had considered. And it could further be argued that the deprivation of liberty without trial is such a grave matter that there is nothing unreasonable or illogical in requiring a Minister or Under Secretary to sign the order when the Secretary of State does not do so, even though the only person empowered to decide that an order shall be made is the Secretary of State. Now, I have to accept, my Lords, that I can't rely upon the practice adopted by a later Secretary of State to establish that one interpretation of the provisions should be preferred to another interpretation of the provisions. But I think what I can bring to the court's attention quite properly is that later practice illustrates how the allocation of the two functions to the different office holders would actually work in practice. If perhaps the most pertinent document for this purpose is a memorandum from the Secretary of State, Mr. Rees, dated the 11th of November 1974, and this is it's at MS 551. It's in the appendix part 2 at MS 551. And this is a document dated the 11th of November 1974, and it's addressed to Lord Donaldson, who we believe was Parliamentary Under Secretary of State for Northern Ireland from 1974 to 1976. And the document notes that all junior ministers had been furnished with a copy. And what Mr. Rees said in the document was, at the start of a new Parliament, I wish to restate the position concerning the signing of ICOs. No ICOs to be signed without my agreement. When I am in Northern Ireland, there is no problem. When I am in the London office, normally details will be new facts to me. I will then give my decision to the duty minister in Northern Ireland, who will sign on my behalf and who will himself have first looked carefully at the individual application. On other occasions, the duty minister will assess the case and call on the Army or the RUC where appropriate before putting the case to me. When not in the Northern Ireland office, I am available in the House of Commons, at the Admiralty House flat, or at my address in Pinner or Leeds. If travelling, the car is contactable. Indeed, one of the reasons for my use of the security car on all occasions is so that I am always contactable. It must be clearly understood that by law, only I can agree to ministers signing ICOs. It is not only a legal matter. To sign an ICO is to work within the law, but a law that allows me to lock up a suspect without going through the normal courts. This process cannot and must not be taken lightly. I wish all ministers to be briefed again concerning the criteria on the strength of the information on which we judge ICOs. And then he goes on to say, evidence of this submitted to Gardiner must be read by all ministers. I'm asking Sir Frank Cooper to arrange for this. So really the arrangement that Mr. Rees was putting in place was almost exactly as envisaged by Mr. Hutton when he was formulating his opinion in 1973. One thing that document also illustrates is that the signing of the ICO, the signing role, was not necessarily confined to an administrative one. Mr. Rees expected the duty minister or the person signing to have looked carefully at the application in the first instance. But the more important point from the perspective of our submission is that there was nothing illogical or unusual about insisting on a ministerial signature. The document was the authority for the individual being subject to executive detention. And one saw that again from the face of the order itself to the governor of HM Prison Maze. This was really the foundational authority for the detention of an individual. The second reason put forward by the respondent refers to the situation of civil emergency and the fact that it would have been impossible or even impractical or even impossible for the Secretary of State to give personal consideration to every request for an ICO. And the respondent refers to the potential volume of requests and the fact that the Secretary of State would not always be present in Northern Ireland. And the respondent also refers to potential communication difficulties in the pre-digital age. I think the word mufax was used in the course of the letter, which is an unusual one in modern day parlance. But the document that I've referred to from November 1974, we say rather undermines those.
We're told somewhere that
suggestions.
there are, Mr. Doran, that there was some 350 applications or 350 orders made in the space of a month.
The numbers were significant. I'm not so sure that the numbers were quite as high as 350 a month, my lord. But I can take your lordship to.
I thought I'd seen that somewhere in the paper.
Yes, the statistics are set out in the Ireland and UK judgment, and that is at MS. It's at Authorities tab 9.
Yeah.
MS 816 and subsequent pages. Let me just see if I can point to the rehearsal of statistics. Yes, my lord, at paragraph 89, it's at MS page 822. It says that figures for interim custody and detention orders under the Terrorists Order and the Emergency Provisions Act are November 1972 to the 1st of February 1973, 166 interim custody orders under the Terrorist Order. November 1972 to January 73, 128 individuals detained under the Terrorists Order and released. November 1972 to September 1973, the commissioners reviewed 579 cases, 296 interim custody orders made under the Terrorists Order or the Emergency Provisions Act, 165 former internments and 118 former detentions. They made 453 detention orders and directed release in the remaining 126 cases. And I think, yes, my lord, I think the figure of 350 to which your lordship refers may have related to the initial phase of internment, and that was an initial one-off operation on.
Wasn't it what was said in
1970.
Parliament? Didn't
Sorry?
it come from what was said in Parliament? Somebody said, I have signed that number. And I can't remember where it was, but I've seen that figure too.
Yes, well, my lady, just in paragraph 39 of the Ireland decision, if one goes back to page 803, there is a reference to 350 persons being arrested in accordance with the special powers regulations. That was at the very outset. That's paragraph 39. And that was at the very outset of internment. Having said that, my lords, my lady, I don't seek to suggest that the numbers were low or inconsequential. In fact, I think there is another document that I will try my best to turn up for the court that does set out some further statistics on the matter. And let me just find that.
Well,
I don't want to take you out of
can-
your course,
yeah,
Mr.
I
Doran.
can-
I've set this hair running. It may not be important.
Yes, although
We're talking about substantial numbers.
we are talking about
And you
substantial.
say that the considerations of convenience are outweighed by the severity
That's
of
correct,
the
my lord.
matter.
But I wouldn't want it to be suggested that I'm minimising the numbers. There were significant numbers of interim custody orders made at the relevant time.
But your submission is they were not such as to take it outside the scope of
No.
the ability of one person to deal with them.
No, my lord. And we say that that view is supported by the later practice of Mr. Rees in 1974.
Quite. The matter that's troubling me slightly is, at the time of the enactment of the 1972 order, of course, it couldn't be anticipated with any certainty how many would be involved.
No.
And the question arises whether this discernible contrast between Article 2 and Article 4.2 and Article 4.3, or 4.1 and 4.2, I'm sorry, whether that was inadvertent on the part of the legislature, and if so, what the legal consequence of that should be. I mean, the argument may be presented that while it's possible on analysis now to draw a contrast between the two provisions and to make an argument that it must be the case that the Secretary of State personally had to consider the question. If the legislature had in contemplation that there might be hundreds upon hundreds of people detained, that it could not have intended that the Carltona principle would be displaced by the phraseology employed in Article 4.2.
My lord, it does seem to me difficult to make the inadvertence argument with reference to the particular wording and structure of Articles 4, 1 and 2.
Well,
does seem-
because of Lord Hailsham's statement, apart from anything else, I suppose. But yeah,
And my lord, the other
I
point,
mean, leaving that aside, I mean, is there not a case to be made on behalf of the respondent that it would be surprising, to say the least, that the responsibility for making the order would be assigned to one individual minister when there was no way of anticipating how many people might have to be detained?
my lord, we say no, given the seriousness of
Yes.
the power. And also, my lord, perhaps it's important to bear in mind, whilst this was a time of particularly heightened violence and threat to security in Northern Ireland, part of the rationale for the appointment of the commission chaired by Lord Diplock was to seek to modify the normal criminal process in order that a greater number of cases could be processed through
Right.
the courts. So certainly it wasn't as though this measure was being introduced at a time when it was envisaged that internment or the practice of internment would be widened. If anything, it was being introduced at a time at which it was hoped that lesser reliance would have to be placed upon resort to the power of executive detention.
And where do you get that from, I beg your pardon?
Well, if one looks at the, again, the Ireland and UK decision, it's at paragraph 50, it's page 808, and this was March, this covers March 1972.
Which paragraph, please?
Sorry, that's paragraph 50, and it's at MS page 806. Sorry, I think I may have given the wrong page number.
Yes.
MS 806. On assuming direct rule, the United Kingdom government stated that one of their most important objectives was to bring internment under the Special Powers Act to an end and to consider how far the powers under that act could be dispensed with. On the 7th of April 72, the Secretary of State for Northern Ireland announced the immediate release of 47 internees and 26 detainees. By mid-May, 259 persons had been released. The decision to phase out internment was not dictated by any fall in the level of violence. Rather, it was intended to open up the way for political progress by reducing tension. On a political level, the United Kingdom was seeking the establishment of an equitable form of government for Northern Ireland acceptable to both communities. The introduction of direct rule, together with the release of detainees, caused resentment and dismay amongst the Protestant community. A 2-day strike, which proved effective, was immediately called by the leader. Now, the text does go on then to refer to the fact that paragraph 53, after the introduction of direct rule, there occurred a marked upward turn in loyalist terrorism, and it goes on to refer to sectarian assassinations. My Lord, there is a subsequent passage of the judgment that is, I think...
Sorry, what particular point are you seeking to make here, Mr. Dorman?
Well, the point I'm making is that the point in time at which the detention of terrorists order 1972 was introduced was quite different from the initial phase of internment in 1971, where internment was seen as a strategy moving forward, whereas by things had moved on.
It was the 9th of August 1971 that internment was introduced.
Yes, indeed. And that was an operation that took place, a wide-scale operation that took place over the course of one day.
Right.
And then the practice of internment continued, but by the time we get to late 1972, it was accepted that the power to intern should remain, but it wasn't part of the political thinking at the time to seek to extend the use of the power.
If you look at paragraph 65 in the same decision, you can see that the Commission noted in its report that subsequent to the introduction of direct rule, the extrajudicial powers appear to have been exercised on a more selective basis. This is from March 1972 onwards.
Yes.
That's the point you're making, isn't it?
It is, my lady, yes. It's just in terms of the inadvertence point that the Lordship raises.
Yeah, so your point is that the adverse reaction to internment may well have fueled the view by parliamentarians that the power to detain should only be exercised after very careful consideration by the responsible minister.
Yes, my lord, and of course the part of the philosophy behind the 1972 order was also to introduce greater safeguards to the power by means of the procedure involving the commissioner.
issue, this is to counteract any inadvertence argument that
Yes, but
that it would have been a considered view of Parliament that the Secretary of State should be personally responsible for deciding to have access to this fairly draconian power of detention without trial.
my Lord, we say there's nothing unusual about them,
Sure,
given,
right.
given the nature of the power. But, my Lord, just before I move on from this point in particular, can I refer the court to a set of statistics at page 550?
550.
550, yes. And this is a document that we think was a government submission to the Gardner Committee that reported in 1975. And one can see that this is an annex to a note on detention procedures. I'll come back to this document a little bit later, but the detention statistics, just to follow on from His Lordship's question earlier, are stated as at 15th November 1974. And it says the number of ICOs made since the 7th of November 1972 was 849. So that seems to cover the period November 72 to November 74. It's not an insignificant number, my Lord.
With regard to the specific point which you're now making in relation to confining the power to make the order to the Secretary of State, is it relevant to this point that there was a power to delegate under the previous order?
Yes, my Lord, there was a power to delegate, and the power had been exercised, in fact, under the...
Could we just see where that is, please?
Yes, indeed, my Lord, that is the... I'm just going to take your Lordships to relevant documents now. If one goes to page MS 590. Lord, 590, there is a document titled the Civil Authority Special Powers Discharge of Functions Order 1972, and the document reads, whereas by section 1.1 of the Civil Authority Special Powers Act and the regulations referred to therein, certain functions relating to the preservation of the peace and maintenance of order in Northern Ireland are conferred on the civil authority.
Well, I mean, it's the question of delegation that I think we want to...
Yes, if one goes to the bottom of the page, whereas paragraph 2.1 of the schedule to the said Act of 72 provides that the Secretary of State may by order appoint such persons as he sees fit to discharge any functions exercisable by him by virtue of section 1.1 of the said Act of 1972. He then goes on, the order then goes on to read, now, therefore, I, the Right Honourable William Whitelaw, MCMP, one of Her Majesty's Principal Secretaries of State, in exercise of the powers conferred upon me by paragraph 2.1 of the schedule to the said Act of 1972, do by this order appoint any person for the time being holding office as a Minister of State or Parliamentary Under Secretary of State in the Northern Ireland Office to discharge the following functions. That is to say, the power to make orders under Regulation 11.2 of the Special Powers Regulations for the detention of persons arrested under Regulation 11.1. Now, the power to make a detention order under Regulation 11.2 became the power to make an interim custody order. Or I should put it the other way, the power to make an interim custody order under Article 4, 1 replaced the power under the old Regulation 11.2 of the Special Powers Act. And Mr.
So my Lord's point is that here there was explicit recognition of the need to make express provision for this power to be exercised by a minister, and that provides the backdrop to the enactment of the 1972 order, and therefore it would sustain your argument that Parliament chose not to expressly confer that power on ministers,
Yes, my Lord.
such as was envisaged by this delegation in 1971.
My Lord, and in fact, the recognition of the need to delegate by formal instrument was recognised. There's a note at page 584. It's difficult to make out the signature, but the author says, I've spoken to Sir Kenneth Jones about powers of delegation to make detention orders. He takes the view that such powers can be delegated. A formal instrument is needed for this purpose, and the instrument should refer to the power on the, should confer the power on the Minister of State in the Northern Ireland office, so that the power remains when the persons holding the office change. So there was as your Lordship has said, it was a recognition of the need to make formal delegation. Now, interestingly,
Who's that sound by? Do we know?
we don't. I can't make out the signature, my Lord. It's a handwritten note, and unfortunately, it's very difficult to decipher.
Well, not to worry.
But my Lord, just very briefly, looking at the provision under which those delegations were made, if one looks at the Temporary Provisions Act, it's in, yes, it's tab 14 of the authorities at MS 984. This was obviously the legislation by which the Northern Ireland Parliament was suspended. But just at the bottom of 986, this is paragraph 2.1 of the schedule. The Secretary of State may, by order, appoint such persons as he sees fit. A, to discharge any functions exercisable by him by virtue of Section 1.1 of this Act, other than the power which is conferred by Section 1.3 to make regulations. That was the provision under which the power was delegated. But interestingly then, 2.1b says, subject to any provision to the contrary in any order in council under Section 1.3 of this Act, to discharge any functions conferred on him by such an order in council. Interestingly, the 1972 Detention of Terrorists order was made under the Temporary Provisions Act, and arguably one could say that 2.1b provided a power to delegate, but we say that, in fact, Article 4.1 and Article 4.2 actually provide a provision to the contrary because of the way they're worded.
Well, what you say is recourse was not had to this.
And was not had to it. So there was no number one, there was no formal delegation. If there had been, a strong argument, we say, could have been made that such delegation would in fact have been contrary to the order.
Do you know whether prior to this statute coming into force and the delegation that you've shown us at MS 590, whether there were powers of delegation in the Northern Irish legislation, or whether the Minister for Home Affairs for Northern Ireland was the only person authorised to make detention orders.
My Lord, that's a matter that I may need to do a little bit further research on before providing an answer. One thing I will say that the provisions actually show, or the materials actually show us that it was only the Prime Minister of Northern Ireland who, in fact, took the decision to intern in practice. There is my learned friend, Mr. Sayers, has brought to my attention the provision in Section 1.2 of the Civil Authorities Special Powers Act. It's at MS 919. And Section 1.2 says, for the purposes of this Act, the civil authority shall be the Minister of Home Affairs for Northern Ireland, but that Minister may delegate, either unconditionally, subject to such conditions as he thinks fit, all or any of the powers under this Act, any officer of police, and any such officer of police shall, to the extent of such delegation, be the civil authority as respects any part of Northern Ireland specified in such delegation. There was certainly no delegation of a power of this kind under that provision. In fact, notably, my lords, my lady, the delegation under the previous legislation was of the power to make a detention order. The ultimate power of internment was not delegated. The specific power of internment under the Special Powers Act was not itself. My lords, the third reason given by the respondent is that the list of persons who may sign includes a Secretary of State, and the respondent says that that would have been unnecessary if Carltona did not apply and Article 2 only provided for authorisation. And they say the Secretary of State does not need to direct himself to authorise his own decision, and his functions under Article 4 are plainly not limited to authorisation. We say that that is also flawed. The way in which these provisions are structured required a reference to a Secretary of State or the Secretary of State in Article 4.2. Article 4.2 is in mandatory terms. Absent the reference to a Secretary of State or the Secretary of State as a signee, the provision would read as follows. An interim custody order of the Secretary of State shall be signed by a Minister of State or Under Secretary of State. That would not have worked, because that would have required signature of an individual other than the Secretary of State who made the order, which arguably would have been an absurd result. If, for example, the legislator had tried alternative wording such as an interim custody order of the Secretary of State may be signed by a Minister of State or Under Secretary of State, that would have been dangerous, because that might have produced an argument that the list of those authorised to sign was not an exclusive list. My Lord, the fourth reason advanced by the respondent is that the wording in Article 4.2 is consistent with the constitutional principle that any Secretary of State could make an ICO. The respondent says that the provision wouldn't make sense if the word sign meant that the persons listed could only execute the document. And they say it would mean that Parliament contemplated one Secretary of State acting on the direction of another Secretary of State. They say that that outcome would be contrary to constitutional principle and would require the power to make an ICO to be restricted in Article 4.1 to the Secretary of State for Northern Ireland. And as they say, there is no such restriction. And my Lord, we say that our interpretation is perfectly consistent with constitutional principle. The order can be made by the Secretary of State and that must mean any Secretary of State due to the provision in the Interpretation Act. If I can just briefly refer to that, it's at page 997, my Lords. And it's a provision within the Interpretation Act of 1954, and it simply says Secretary of State shall mean one of Her Majesty's principal Secretaries of State. So we say the order...
Which provision? Oh, yes, that's exactly.
Yes. So we say the order can be made by any Secretary of State, normally the Secretary of State for Northern Ireland. The order can be signed by any Secretary of State. Normally that will be the Secretary of State for Northern Ireland if he makes the order. And in normal practice, the Secretary of State making the order will also sign, except where by necessity the signing has to be by one of the other ministers. There is a possibility, of course, left open by the legislation that an order could be made by one Secretary of State and signed by another, but we say that that's highly unlikely to have arisen in practice. Can I just refer the court very briefly to one specific arrangement that was actually put in place by Mr. Rees when he was going to be out of the country. And that was between the 30th of July and the 5th of August 1974. If one goes to page MS 555, I needn't read this document in full, but it is a letter dated the 26th of July from the Northern Ireland office to the Home Secretary's private secretary. And the letter reads, "Our offices have been in touch on the telephone about the making of interim custody orders while our Secretary of State is out of the country from the 30th of July to the 5th of August inclusive. I understand that the Home Secretary is willing to help." And the letter goes on to give some fairly detailed explanation of the way in which these provisions work. But significantly, on the second page of the letter at MS 556, the letter talks about wherever possible, we shall provide written submissions with an analysis of the evidence, but when the timing precludes this, I understand that the Home Secretary is prepared to receive telephone calls on these cases at his home. This will meet the requirements of the Act, and Mr. Merlin Rees would be most grateful to him. And at page 554 then, just going back, there is a response to that letter from the Home Office, and it says, "Thank you for your letter to Sid Morris of the 26th July. I can confirm that the Home Secretary is willing to help in the making of interim custody orders." So the view had been taken by Mr. Rees and his officials that if it really was going to be impossible for him to give any personal consideration to the matter, then another Secretary of State, in this instance the Home Secretary, would have to be asked to step in and deal with the matter. Now this leads me on, my lords, my lady, to the sixth stage in the submission, in which I wish to make some reference to the extreme nature of the power. And I don't need to say too much about this perhaps, but there are two basic points. The first is that the power was one of the most extreme in nature to be vested in the executive. And the second is that none of the deprivation of liberty cases, as I will describe them, none of those cases, none of the authorities cited in the judgment of the Court of Appeal are truly analogous to this case. And, my Lord, one does not have to look too far to find observations on how significant a departure from normal procedure these emergency powers entailed. The point is perhaps most forcefully expressed in a quote from the Gardner Committee report, which is set out at paragraph 68 of our case, and that is at MS 95. And the original quote appears at MS 1444. And the quote says, "Detention involves a decision by government to deprive individuals of their liberty without trial and without the normal safeguards which the law provides for the protection of the accused. It is an executive and not a judicial process. It is not known to the common law and is only justified in a democratic society in times of the gravest emergency for the
Sorry,
purpose-"
144.
1444.
1444.
Yes. And that, as I've said, that is from the Gardner Committee report itself.
This is 1975.
Yes, yes, my Lord. And it's at paragraph
118.
118. Yes, thank you, my Lord. Described as not known to the common law and only justified in times of the gravest emergency for the purpose of the greater protection of the public. Notably, the power involved a notice of derogation under Article 15.3 of the European Convention. And that is, the derogations are set out in the authorities at tabs 36 and 37. That's MS 1456 and MS 1457. I needn't take the court to those. In the written case, the court's attention is also drawn to the observations of the Appellate Committee of the House of Lords in A and others, and Secretary of State for the Home Department, which appears at Authorities tab 22, MS 1046. Now, the case did not involve Cartona, but it did involve a system of executive detention without trial. And the statutory basis of the scheme is the Anti-Terrorism, Crime and Security Act 2001. And under that legislation, there was, of course, a fairly elaborate system of appeal to the Special Immigration Appeals Tribunal. But there are several observations in the judgments on the nature of the power of executive detention, and we bring the court's attention to those at paragraph 73 of our written case, and that's at page MS 97. And we give three examples, one from the speech of Lord Nichols, who described indefinite imprisonment without charge or trial as being anathema in any country which observes the rule of law. Lord Hoffman's point that nothing could be more antithetical to the instincts and traditions of the people of the United Kingdom. And Lady Hale's observation that executive detention was the antithesis of the right to liberty and security of person. What's also interesting is that Lady Hale described the safeguards in the 2001 legislation as being greater than under any other or any earlier internment powers. So the powers that we're talking about didn't have the degree of safeguards that were contained within the legislation that Lady Hale was discussing. And we simply make the point that if the nature of the power before the court is not such as to tip the scales in favour of the Cartona principle being ousted, then it's rather hard to imagine any loss of liberty provision being interpreted in this way.
Right.
Now, my
Where are we
lords,
now?
my lady,
Where are we now?
well, we're coming very close to the finishing line.
Good.
My lord, I'm not going to go through the liberty cases, if I can describe them as such, in any detail in my oral submissions. I simply want to say this. None of the three cases cited in the Court of Appeal's judgment, those are Doody, McCafferty, and Harper, none of those cases involved an analogous power. They were all cases that concerned powers that were either within or attached to the normal criminal process. Doody was about the setting of tariffs in life sentence cases. Cafferty was about the revocation of licenses. Harper was about extended periods of detention for questioning, but as a prelude to the criminal process. So the culmination of that process in Harper was the individual was charged or the individual was released. Doody and McCafferty were cases in which the decisions concerned followed on from criminal trials, full, normal criminal proceedings, which we say are qualitatively different from this case. And we also make the point that the relevant provisions in none of those cases had the textual force of Article 4.2. So the framework and the wording of the legislation in this case is different. The nature of the power is significantly different. Now, before I draw to a conclusion, I very briefly, my lords, draw attention to a few matters that I don't think will take up too much of the court's time. One I've already mentioned, and that was reliance on the detention order to cure any defect in the original ICO, and that matter isn't being pursued.
No.
There was also reliance before the Court of Appeal on the presumption of regularity, and the Court of Appeal disagreed and said reliance couldn't be placed on the presumption of regularity in these circumstances where the Secretary of State hadn't actually considered the case. That matter isn't being pursued by the respondent. My lord, there is also a reference in the cases to Pepper and Hart, and we had suggested before the Court of Appeal that if the court were to consider the provisions to be ambiguous or apt to lead to an absurdity, then some reliance might be placed upon the comments made by Lord Hailsham prior to the introduction of the 1973 Act. My lord, we don't press that point strongly on appeal. If your lordships were to take the view that the provisions were ambiguous or apt to lead to absurdity, then we would say that reliance could be placed on those words. And we, needless to say, we don't agree with the potential reliance placed on comments made by the Minister and the Attorney General prior to the introduction of the 1972 order that are referenced in my learned friend's case. Now, on the conclusion, or just to conclude, on the basis of these submissions, we submit that the ICO of July 1973, which authorised the appellant's detention, was unlawful. And it follows that an essential element of the offences for which he was convicted was not established in evidence. And for that reason, we respectfully ask the court to find that the convictions were unsafe and should be quashed. To finish my submission, I think it may be appropriate to reflect on how an appeal hearing in this case might have proceeded in 1975 or 1976, in the early months or years after the convictions. By that time, the interpretation that is now advocated on behalf of the appellant had been officially endorsed. I've already referred to the practice of the later Secretary of State. The court will see references to other documents in paragraphs 24 to 28 of our case. There is, however, one document to which I would refer the court specifically, and it appears at Appendix Part 2. The page reference is MS 541, and it's the document from which I took the statistics earlier in the submission. And this document is undated. The statistics to which I referred earlier in the annex are stated to be as at November 1974. And we think that it might be the government's submission to the Gardner Committee. My Lord, if I can just turn up page 544. The paragraph 10 of the document states, and it's clearly an official document from the relevant period. Paragraph 10 says, although an ICO may be signed on behalf of the Secretary of State by a Minister of State or Under Secretary of State, only the Secretary of State himself has the power to make the order. For this reason, the Secretary of State is always consulted, whether in the province or not, before an ICO is signed by another minister. Had the appeal been heard in 1976, the respondent would have been in the rather unusual position of advocating an interpretation of Article 4 that ran entirely contrary to the official understanding at that time of how this provision was meant to operate. And we say that our interpretation, first advocated by Mr. Hutton and later accepted by the Secretary of State and finally endorsed in the official literature, was the correct one. It was correct in 1973 when the order was made, and it remains correct today. Those are my submissions.
Thank you very much indeed, Mr. Doran. Mr. Sayers? Mr. McLennan?
The prosecution service in this appeal. We invite the court to uphold the judgment of Lord Justice Weatherup in the Court of Appeal below. I intend to follow broadly the structure that my learned friend Mr. Doran has adopted this morning. Firstly, I want to examine the constitutional, political and legal context that pertained in Northern Ireland at the making of the particular order in 1972. I'll take the court succinctly, I hope, through some of the original documents in order to highlight a number of features to the court. Secondly, I want to examine the Carltona principle, its operation, the scope for ouster of the Carltona principle, and the subsequent case law that emerged in the 1970s and through to the 1990s. Then I will turn to the legislation itself and examine Article 4. And then finally, I will address the gravity or seriousness issue which my learned friend concluded his submissions upon. Ultimately, our submission in the case will be that Carltona applies. We say it's not displaced by any implication. We say that there is a limitation on Carltona in Article 4.2, so that the power in question can only devolve to the persons identified in Article 4.2. We say that the detention of Mr. Adams was consequently lawful, and the conviction, we say, was properly Firstly, the constitutional and political background. Prior to March 1972, Northern Ireland was a self-governing, devolved state with its own parliament, its Stormont. It operated pursuant to the terms of the Government of Ireland Act 1920, which is among the papers. There was no Secretary of State for Northern Ireland. There were Northern Ireland ministers, and power was exercised through the Northern Ireland departments.
There was a governor, wasn't there?
Yes, there was a governor, and through him, power was discharged by the Northern Ireland departments, each of which had a head. And it is interesting, even to this day, that the Carltona principle is not a prominent feature of the devolved governance arrangements in Northern Ireland, because in large measure, powers are exercised through departments, not ministers. So there was not a culture of the application of Carltona under the governance arrangements that pertained until 1972. In March 1972, amidst a severely deteriorating security situation involving widespread disorder and extensive loss of life, the devolved system of government was suspended and direct rule was introduced. Helpful historical insights can be found in the Ireland versus United Kingdom judgment of the Strasbourg Court, to which some reference has already been made. The Court has turned to that already. I'd like to highlight some of the passages in that to give the Court some helpful contextual background. The judgment begins at MS 790. And of course, this judgment followed upon an extensive examination by the European Commission on Human Rights, which ranged over a protracted period of time, produced a very voluminous report which informed this judgment. But in the search for an objective history of what happened in Northern Ireland in the 1970s, which is difficult, this is a valuable resource. It's valuable insofar as it identifies the scale of the difficulty with which the authorities were faced at that time. And the Court will note, for example, MS 805, paragraph 48. From August 1971 until 30th of March 1972, there had been in Northern Ireland 1,130 bomb explosions, over 2,000 shooting incidents, 158 civilians, 58 soldiers, 17 policemen have been killed, and 2,500 civilians, 300 soldiers, and over 100 RUC members injured. 233 citizens were killed during that period. This was truly an exceptionally challenging time for governance in Northern Ireland. Because of this deteriorating situation, the Northern Ireland government arrangements were suspended, and the Northern Ireland Temporary Provisions Act 1972 was introduced. That Act, which the Court will find at MS 984, by Section 1.1, installed the Secretary of State for Northern Ireland, an office hitherto unknown, in place of the Governor of Northern Ireland, provided that no person was to hold office as Minister of Northern Ireland, so the ministerial structures were swept away. All functions of the Governor, the Government, the Northern Ireland Ministers, or any Northern Ireland Department were to be discharged by the Secretary of State for Northern Ireland. So the Court can see at this juncture in March 1972, the totality of governance arrangements in Northern Ireland were to be exercised through the Office of the Secretary of State for Northern Ireland. An important contextual factor when one comes to examine issues of volume and capacity and the need for the application of Carltona. The legislative authorities were also suspended. The Northern Ireland Parliament was prorogued. The Queen was authorised to legislate by way of order in council. and the court will see provision was made for urgent orders in council to be made by way of the procedure in Schedule 1, paragraph 4. That's at page 987. That was the provision that was used to make the 1972 order that is impugned in these proceedings. And it explains why, in this case, the order which...
I don't know that the order is impugned, is it? Its interpretation is asserted by the appellant. It doesn't. The appellant doesn't seek to cast the order aside, does it?
No, I think that's right. Indeed, perhaps it should be endorsed. We say in our interpretation, but it's the focal point of the case. And
right.
The reason I draw attention to this is because, in fact, this scheme allowed for the making of urgent orders in council. This order in council was made and debated after it had been made by Parliament. The debates take place after the order is actually in place, and all of that reflects the urgency and the need to address the growing and continuing crisis in Northern Ireland. We say an important contextual fact. The question of the making of detention orders surfaced almost immediately upon the Secretary of State's appointment. So he takes office and assumes the responsibilities for the entirety of the machinery of governance on the 30th of March. But by the second week in April, issues are arising about the making of detention orders, and we can see that from some materials that the court has already seen in part in our consideration of the issues today. The MS 589, which is in Appendix 2 of the bundle, the document begins at 587, contains a briefing paper to the Secretary of State on the 18th of April 1972, referring to the fact that on his arrival in Belfast he was asked to sign 2 detention orders. There's then a discussion about the challenges that arose and how this might be managed as matters go forward, and various options are canvassed, including the prospect of delegation. And that briefing to Mr. Whitelaw, the Secretary of State, concludes at page 589 with the observation that all its difficulties, delegation is the lesser of the 2 evils. The question then arises to the extent of the delegation, and they seek his direction. And the manuscript note is actually in the hand of Mr. Whitelaw himself, who is saying, "I must delegate when I can't do it myself. I am quite content to do so." And one sees that evidenced at page MS 594, where there's a senior civil servant noting the annotation in manuscript form. And what flows from that is, again, you've already been shown the instrument of delegation at page MS 590. Pursuant to the power under the 1972 Temporary Provisions Act, the Secretary of State executes an instrument of delegation allowing for these detention orders to be made by either the Minister of State or the Parliamentary Under-Secretary of State. So, the volume problem, the capacity issue, the extent of the crisis led to a policy decision being taken, executed by virtue of the extant statutory scheme, to allow for detention orders, which are directly analogous to the inter-custody order in this case, to be made by either the Secretary of State or the Junior Minister or the Parliamentary Under-Secretary of State. Now, we can see from the Ireland and the United Kingdom judgment, Strasbourg, again, how matters unfolded. It has that at MS 800, following.
Sorry,
MS 805.
800, yes.
I've already shown the court paragraph 48 of the judgment, but this time period is examined by the European Court from paragraph 50 on. So you've seen that at page MS 806. And my learned friend has highlighted some of the passages in this part of the judgment. We would highlight to the court from paragraph 53 on that after the introduction of direct rule, despite the aspiration that this would lead to a reduction in violence because internees were being released, there was an upsurge in violence. There was an upsurge in loyalist violence, more kidnappings, murders, shootings. These are detailed at paragraph 54. There was then a ceasefire in June 1972 when the official IRA and then the provisional IRA both announced a truce, which was called off on the 9th of July 1972. We invite the court to note paragraph 55. After the breakdown of that ceasefire, provisional IRA violence was resumed at an increased level. In July 1972 alone, 21 members of security forces, 74 civilians were killed. In addition, there were nearly 200 explosions and 2,800 shooting incidents, the highest for any month in the entire emergency up to the end of 1974. 95 civilians were killed in the month of July 1972. In response to this further deterioration, the government initiative was to commission Lord Diplock to commence a review of the extent to which the ordinary process of criminal justice could cope with a scenario where there was alleged intimidation of witnesses to the extent that the criminal justice scheme could not function properly. And he was commissioned in September 1972 to prepare a report on these matters. But before he could report, and he ultimately reported in December 1972, the 1972 order with which we are concerned came into force. And the court has that at page 615 of the same book of authorities. And it's plain on its face from 615, from the first paragraph and the recital, that this was an urgent instrument. You will see, whereas we made to appear to Her Majesty that by reason of urgency, this order requires to be made without a draft of being approved by resolution of each House of Parliament. And that was using the special provision in the schedule to the 1972 Act in order to respond to this particular need. Now, I've shown the court that there was an instrument of delegation in place up to November 1972, which allowed for Ministers of State and the Under-Secretary to make the equivalent detention order. My learned friend has observed that it would have been possible to continue or include a delegation in the new order pursuant to the same provisions in the schedule to the 1972 Act. Our submission here, of course, is that would have been entirely odious, given that Carl Tona applies. This is a settled and accepted constitutional principle. If Carl Tona applies, then there would have been no need for delegation. The policy was set, we say, in April 1972. The capacity, the volume, the crisis required that orders be made by those other than the Secretary of State. There's not a single document that shows there was a change in that stance. And a Carl Tona reading of the 1972 order allows for continuity of that same approach in circumstances which are the same or worse than those which applied in April 1972. So this order was made on the 7th of November 1972. Because of its urgent nature, it was not debated in advance. It was debated on the 11th of December 1972. The court has the Hansard debates, beginning at page 1522 of the authorities bundle. I think that's in your volume 3. Some members of the court have obviously looked at these already, and there is an issue about the application of pepper and heart in a case such as this. But if the court is to examine the parliamentary materials, we say they support the construction which we intend for. The debate was introduced by the Minister of State, Mr. Vaughan Straubensy, at 1522. The court can see his observations. At 1534, MS 1534, he is challenged on the fact that he stated in his submissions that he had been involved in the signing and making of orders pursuant to Article 4.1. And Sir Elwyn Jones challenges him about this and raises the issue in terms of seeking a response from the Attorney General on this particular issue. The response on that comes at page MS 1577. So the Attorney General is replying to the issue raised about who can make these orders, and the second substantive paragraph on that page. I won't read all of it. But at the halfway down that paragraph, it refers to one of the principal reasons for it being only the Secretary of State under Article 4.1, whereas under Article 4.2, an interim custody order can also be made by a Minister of State. It's a need for speed which sometimes arises. The Secretary of State is not always there, but the Minister of State and the Under Secretary of State can take this very preliminary step, and there's rigorous inquiry before it's taken. Then he's asked about that again. Does this mean a minister so designated outside the Northern Ireland Office will be able to act? In practice, it will mean only the Secretary of State, the Minister of State, or any Under Secretary of State in the Northern Ireland Office, because they will be the ministers in Northern Ireland. All they do is make the interim custody order, where it so appears, when the order has been made, and so on. He discusses what has been made. So we say that is consistent with the approach that had been adopted from April 1972 to allow for ministers to make the orders, not just the Secretary of State. Now,
are you going to refer to Lord Hailsham's observations?
I wasn't going to rely upon them, my Lord, but I think the court's already seen them. So.
Yes, well, you don't have to if you don't wish to, but I just wanted to make sure that you were alert to those observations, which might be thought to be in contradistinction to the comments that the Attorney General made.
Yes, well, we're not necessarily relying on these materials, but we say this isn't a case that ought to require the court to go to pepper and heart. But what we say is...
In fairness, Mr. Doran has not urged us to have regard to the parliamentary materials.
Well, I think our approach is, if the court is driven to it, then one needs to balance those observations of Lord Hailsham with the Minister of State in reducing the legislation and with the Attorney General's observations.
Right, fair enough.
There is an additional interpretive aid, we say, that is, again supports the proposition we contend for, and that relates to the Emergency Powers Act 1973, which was the instrument which replaced the 1972 order. The Emergency Powers Act came into force on the 8th of August 1973. Of course, the appellant in this case, Mr. Adams, was detained pursuant to the ICO on the 21st of July, just before that came into effect. But what we do have in the papers is the notes on clauses for the 1973 Act, and the court will find those in the Appendix Volume 2 at page 531. And the notes on clauses are a precursor something of a precursor to explanatory notes, which one sometimes finds in statute provisions now. This is a difficult document to read, I'm afraid, but if the court will allow me to assist, the notes of clauses are prepared in relation to the clauses of the bill as it's going through Parliament, and the court will note that Article 4.1 and 4.2 are replicated almost verbatim in the paragraphs 11.1 and 2 of the schedule to the 1973 order, and that's what's being discussed. If the court can see paragraph 6, halfway down that page, there's then a discussion of interim custody orders. Begins subparagraph 2, requires an interim custody order to be signed by the Secretary of State or a Minister of State or an Under-Secretary of State, i.e. a Parliamentary Under-Secretary of State or a Permanent Under-Secretary of State. Then the note, as a matter of law, a Minister may act by any officer of his department. In the case, however, of matters affecting the liberty of the subject, it is customary to include a provision such as this to ensure that it appears on the face of the instrument that the matter is being considered at a high level. In any event, the policy being implemented is that of the Secretary of State himself. So the point being made here in respect of the successor clause was Carl Tona applies, but because liberty's in play, the gravity of the scenario, then you identify the level above which the instrument can be made. So it can't be any official. The statute itself identifies specifically the cohort of ministers who can discharge this function. And that explains, we say, the text in Article 4.2. Article 4.2 of the 1972 order provides a floor to identify the particular individuals who can execute and make an order of this nature.
Well, why does it say sign rather than execute and make an order?
Well, various formula could have been chosen, my lord, but we say whenever one understands the application of Carl Tona, and Carl Tona is at large because of 4.1, 4.1 opens the possibility of anyone making it, and the limiting clause is brought in 4.2 and identifies and confines it to that body.
But what's the logic of that? I mean, if 4.1, on your interpretation, I think Mr. Doran is disposed to accept that if 4.1 stood alone, Carl Tona would probably apply. But 4.2 introduces a distinct refinement, and it says that only ministers, or I can't quite remember the terms of it, may sign the order. Why would it need to do that if 4.1 had the extensive effect that I think you argue for?
Well, one of the indicators is in this document is to demonstrate on the face of the statute clearly who can make these instruments, so that it is a public expression of the limitation, and the concept of signing is the way in which that is put forward in the statute.
Well, was 4.2 necessary at all?
Well, necessary insofar as if one didn't have 4.2, then one could be open to the challenge that any official could make an interim custody order, a superintendent in the police service, for example, as was the case with the civil powers legislation. Yes. It could be delegated to a superintendent with all that brought with it in the contentious circumstance of Northern Ireland. So 4.2 is an indicator of the potential cast of senior.
But why not introduce that to 4.1, where its logical position would be more appropriately located?
Yes, well, I'm not sure I have a ready answer to that.
Why use the word make in 1 and sign in 2 when you're, both cases, getting at making it? Again,
it's not straightforward to reconcile why the different terminology is used. One, again, recognises the fact this was an order in council made under the urgent procedure we say to carry forward a process that had already been identified by the delegation scheme in April 1972. It's a continuity of policy. The language is used, we say.
Can you just help me by telling me what the precursor was precisely?
To the 72 order.
To 4.1, yeah, to the 72 order.
The precursor was the Civil Powers Act 1922.
The 1922 one?
Yes, and it was
And section?
11.
Thank you.
The reference for it, my lady, is at MS 935.
Thanks very much.
I think, known notoriously in that non-pejorative use of that term as the Special Powers Act.
Yes, the 56 regulations, which I'm showing you at MS 935, contain the amendment of Regulation 11.
Which was the specific?
11.2. The text can be found at the top of page MS 936. Allowed for the detention following arrest, and that power then could be exercised by the Secretary of State for Northern Ireland upon taking up his functions under the 1972 Act.
Yes. Yeah. It was a power originally vested in the Minister for Home Affairs, wasn't it?
Yes, that's right. Although it could be delegated.
Where's the power for delegation?
It's a constable provision, isn't it?
Is that not in the 1922 Act?
It's the 22 Act.
Yeah,
We looked
it
at
must
it
be,
earlier.
but I just wondered where it was.
Page 919. Sorry. Subsection 1.2.
Yes.
Yes, section 1.2, yes. In fact, Mr. Doran took us to that.
Yes. That allows for delegation not to a junior minister, of course, but delegation to an officer of the police. So again, casting one's mind back to the controversies of Northern Ireland in the early 1970s, and as my lord indicates, the Special Powers Act regime, those provisions allowed for delegation to a police officer of powers of detention. And the 1972 regime introduced by the delegation instrument, first of all, and then by the order, makes it plain on its face that this will be dealt with at ministerial level.
This power is being replaced by a new power, and
Yes.
it's intended that you say that there should be a power of delegation, but that it should be limited.
Yes.
It's a very strange way of setting about it, isn't it?
Well, it's idiosyncratic. I accept that. The 1972 scheme becomes a 73 Act, and is replaced again or replicated again in the 1975 Act. The same model applies. And the Lord says it's a strange way of going about it, but one can look at this a different way. The argument here is that Carltona has been ousted in this case. At that time, if one looks at contemporary statutes where Carltona has been ousted, it is done by a particular formula, where there's an express requirement that the Secretary of State, acting personally, makes the decision. One sees that in the Immigration Act 1971, which is the subject matter of the Ulada Hindi judgment, one of the seminal Carltona cases.
Yes.
And that's a good example of what Parliament would do if it was deliberately trying to displace Carltona and reserve a power to a Secretary of State specifically, which is what the appellant says happened here. And we say it's very interesting. In 1971, the Immigration Act used that formula, and that formula has been used in other examples. There are other statutory instruments that have adopted the same technique to oust Carltona. So, while I accept it's idiosyncratic, it's a very, very odd way to go about ousting the Carltona principle. And we say it lacks any form of precision, which one would normally expect in the formulation of an ouster clause in an area of this nature.
Thank you.
So,
If I've understood your submission, it's not that Carl Toner is ousted. It's that 4.2 provides the four corners within which the Carl Toner principle may operate.
Yes.
In other words, your submission, looking at the language, is that the only people who can make this decision are ministers of the Crown.
Yes, it's a limitation on Carl Toner, we say. My learned friend's case is Carl Toner is ousted by those words, and we say that that can't be right, because one looks to the Immigration Act, for example, and I'll come in a moment to some other examples of that, and one sees how Parliament does it, because it does require precision, and you do it by putting a formula forward that requires the Secretary of State to act personally, and not by this rather peculiar interpretive route. 756. While we're on that point, one can see what I'm referring to here. If one goes to MS 756, this is the judgment of Lord Griffiths in the House of Lords in Olada Hinde. One sees here, this is a case about whether or not immigration officers can discharge certain functions, or whether it can only be the Secretary of State. And the points made at below letter C, it's well recognised when a statute places a duty on a minister, it may generally be exercised by a member of his department for whom he accepts responsibility. This is the Carl Toner principle. Parliament can, of course, limit the minister's power to devolve or delegate the decision and require him to exercise it in person. There are three examples of such a limitation in the Act of 1971, and he recites section 13.5, and you'll see that this is a person shall not be entitled to appeal against the refusal of leave to enter or against the refusal of an entry clearance if the Secretary of State certifies the directions have been given by the Secretary of State, and then the ouster of Carl Toner, in parentheses, and not by a person acting under his authority. And there are two other similar examples in the Immigration Act. Again, 1971, we're looking at an order which is approved by Parliament in 1972. But this formula is, again, repeated in other contexts. If one looks, it's not in the papers, but the European Economic Area Regulations 2000, crucial instrument in immigration law, has the same formula within it, again, reserving specifically to the Secretary of State
What's the reference to that?
Regulation 31, subsection 4 of the EEA Regulations 2000.
Which page is that?
It's not in the papers, I'm sorry, my Lord.
It's
It's a continuation of the same concept in a modern formula.
Well, do you have copies of the provision?
I can have those produced.
Yeah. That would be helpful.
There are,
Of course, the point being made in the one we've just been looking at is where Parliament has chosen to make express provision within a statute, we're not going to imply it very easily.
Yes.
It's not requiring the use of that formula or
no,
anything.
I accept that. And it's not always that formula. There are other statutory examples where a slightly different form of words is used, but again, it is made clear that it is to be the personal exercise of the power by the Secretary of State. There's a reference in the papers to the Serious Organised Crime Police Act, Section 71. It's in one of the academic articles by Mr. Laird. Refers to the Secretary of State for Business and Energy acting personally. There are similar examples in the Investigative Powers Act 2016. We refer to that in our written case at MS 120. So there are dotted through the statute book clear examples of how Parliament ensures by express language that it ousts Carl Toner, and that formula was not used in this case. We say, in contrast, what was done there was a limitation by 4.2 of the scope of the Carl Toner principle, no more than that. And almost by extrapolation.
I mean, it's slightly incongruous, is it not, that Carl Toner applies in full force, your submission, to the making of the detention order, but it is refined and restricted in relation to the signing of the order.
And making, my Lord, we say signing and making. We say signing and making are two read together. It applies. The limitation applies to the making and the signing of the orders, both.
Oh, I see. So, well, why does the same formula not be employed in Article 4.1 as in Article 4.2, if that's going to be the effect?
Well, Article 4.1 is the straightforward expression of the power residing in the Secretary of State. So it's a freestanding provision. It doesn't need to have the limiting component in it.
Well, if 4.2 wasn't present, 4.1 would, on your submission, introduce the Carltona principle in full panoply, and there would be no restriction at all.
Yes.
But your submission is that Article 4.2 not only applies to signing and therefore introduces a refinement of the Carltona principle, but somehow is transposed into 4.1 as well.
It applies to the making and the signing of the order, we say.
So in a sense, if I understand your submission correctly, Clause 4 is concerned with the nature of the power, and 2 is concerned with the execution or the implementation of that power, the exercise of that power.
Yes.
And and that's why the limitation appears in 2. Yeah.
I still can't quite understand why it doesn't also appear in 1, or at least that there isn't a reference back in 2 to 1. I mean, that would have been surely the sensible way of making the provision, if it has the effect that you contend for.
It could have been drafted in various different ways, my Lord, I accept that. But we say this provision, read with the well-understood constitutional principle, is sufficient to achieve the outcome that we argue for. So I go back to my chronological examination of this issue. I've shown the court how this has developed into the 1973 Act. I've shown the court the notes and clauses for the 1973 Act. It is clear from the archive papers that there was a dispute among government lawyers as to the scope of the Carltona principle and its application to Articles 4.1 and 4.2. And one sees correspondence being traded on this issue between the Attorney General's office in Belfast and London. And the debate emerges in December 1973. There are contemporaneous documents which the court might find of value in respect of that at MS 527. And one sees, actually 529 is on 4th of December 1973, an official in the Law Officers Department in Belfast is querying whether or not the Secretary of State is required to make all of the interim custody orders. And this is Mr. McMahon who commences this debate. And that's responded to by Mr. Howard Drake on the 20th of December 1973. The letter begins at page 527. And he challenges this view on the basis that Carltona applies. He refers to the notes on clauses, which I've shown you at paragraph 3. And at paragraphs 4, 5 and 6, he records their exchange of view and ultimately settles upon the position that the safer course would be for the Secretary of State to be consulted whenever interim custody orders are made.
Which paragraph is that, please?
Paragraph 5. So the last sentence, the Secretary of State should be consulted personally in all cases. The next paragraph, to avoid difficulty in the future, it would be wise for as far as practical always to consult the Secretary of State as already advised. I think this is as far as we can go. That we must recognise that there will be frequent occasions where the Secretary of State cannot be consulted personally.
So Mr. McMahon had said that where ICOs were not personally considered by the Secretary of State, it was his view that they would be unlawful.
Yes, that's right. And that wasn't necessarily accepted by the Attorney General's office, who took the view that Cartona applied, referred to the notes and clauses, but seemed to have come to the position that in light of this, the course they would take would be to consult the Secretary of State, recognising that he wouldn't always be available in relation to the making of interim custody orders. And all of this predates Mr. Hutton's opinion, which emerges later in 1974. So the view taken by the AGO's office at that time is contained in those papers. We know that there was a change of government in March 1974. Mr. Whitelaw was no longer the Secretary of State. I think Mr. Pym had succeeded him, but we now had a Labour government, and Merlin Rees took over the office. And under the new government, the question of interim custody orders is examined again. Mr. Hutton's opinion is commissioned and produced in July 1974, and that informs a next phase of debate on these issues. And I see the clock's just turning to 1.
Right.
So,
Well, we'll resume our intriguing historical tour d'horizon at 2 o'clock.